Welcome to the CaseBank 7-minute update for September 2020. 1. Since marijuana use is now legal, the court may not make no marijuana use a term of probation unless the lint criteria is met. The fact that the defendant used marijuana hours before committing the crime is not sufficient connection to the crime to support a probation term. The defendant was not under the influence of marijuana at the time of the crime. Case 2. The defendant's sexual violent predator petition is dismissed after 13 years of consented to delay. Almost all of the delay is attributable to the Los Angeles Public Defender's Office lack of adequate staffing to their sexually violent predator unit. Case 3. Minor pleads guilty to robbery. After completing probation, minor seeks to seal the juvenile record for Welfare and Institutions Code Section 786. Held, the court does not have the authority to change the robbery to some other charge to get around 786's prohibition on sealing records for 707B crimes. Case 4. Successfully completing diversion under Prop 36, Penal Code Section 1210.1, does not qualify a person for the remedy of sealing his arrest record under Penal Code Section 851.91. Case 5. Defendant files a 1538.5 motion to suppress evidence. The motion sets forth the defendant's version of the facts. The DA's response admits to all of the facts and argues only the law. Held, the court has discretion to deny the defense request for live witnesses at the hearing. Case 6. Question: do defendants found not guilty by reason of insanity under Penal Code Section 1026 get 4019 good time for their time spent in custody? Answer: yes. Case 7. Due to amendments to three-strike law made by Proposition 36, consecutive sentencing for all serious and violent felonies is now mandatory. The courts of appeal are in conflict on this issue. Case 8. Defendant offered evidence that his childhood, partially spent in a Thailand refugee camp, made him overly deferential to police and caused him to confess to something he didn't do. Held, it was error to not admit such evidence, but harmless in this case. From the same case, CalCrim 358 language regarding viewing with caution unrecorded admissions of guilt is for defendant's benefit. If defense attorney has a tactical reason to not want it, it should not be given. There is no sua sponte duty to give this instruction. Case 10. Human trafficking under Penal Code Section 236.1b does not require proof that the adult victim did not consent to her confinement, and proof of consent is not an affirmative defense. Case 11. The Department of Corrections sends a recommendation to the sentencing court to recall defendant's life sentence after 12 years in prison. The recall is under PC 1170D sub 1 and is based on the defendant's exemplary prison record of rehabilitation. Held, court has discretion to set this request for hearing or to summarily deny it. This case, however, it was an abuse of discretion to not set for hearing. Case 12. The defendant, now age 69, entered the MDO program in 1999. He remains schizophrenic. He is in denial. He resists treatment. He goes AWOL when put on CONRAP release. But he has not done a violent act since his 1990 crime. Court of Appeal reverses 2019 extension. Insufficient evidence the defendant is a harm to anyone. Case 13. Defendant is found not guilty by reason of insanity of a murder committed in 1975. Record at the 1026.5 extension hearing shows that while the defendant is still mentally ill with delusions and paranoia, he has been able, with medication, to control his behavior. There's not been a single violent outburst for 45 years. Hell, the 1026.5 extension is reversed. To download a PDF of all the cases added to the CaseBank database during September 2020, or to download the entire database itself, go to our website at casebanklaw.com.